Good afternoon. This is Judge Alyssa Perez, resuming the civil docket for the 210th District Court for March 2nd, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Pantoja, would you call our next case, please?
Yes, Judge. It's 3319 on page 6.
Okay.
It's cause number 2019 DCB 3319. Nelly Vidana versus Angelina Minerva Reyes et al. Announcement to council, please.
Joe Shelley on behalf of the plaintiff.
Ashton Nunez on behalf of Allstate.
Okay, gentlemen, final status conference. How are we doing on this one? We have a jury trial set in April.
Your Honor, this settled with the tortfeasor, and so this is just an underinsured case at this point. At this point, and I don't believe Mr. Nunez has had the opportunity to depose my client yet.
So, Judge, we actually got a new adjuster on this case, so we're kind of in the midst of a transition. We should have a new adjuster assigned by the end of the month, but we actually reached out to Mr. Kennedy's office to see if we could schedule a meeting, maybe kind of do another mediation on this case prior to the jury trial. In the meantime, we could keep the jury trial date.
Do you think, I've been hearing some things about scheduling mediations this morning. I mean, we, even if I gave you until docket call, do you think you could get something scheduled before the 20th
I think,
April?
Judge,
You feel good about it?
I feel good about it. I got one scheduled, from one day, to the next. So it'll work. If our adjuster works with us, Judge, I have no issue with it, but I will push for it. And, I don't think Mr. Shelley's office is going to have any issue with it as well. With the past mediation, it didn't get settled, but I think, we weren't too far off in terms of the numbers.
Everyone's optimistic. Let me ask, with your permission, can we do this? Just because that trial date doesn't seem like a real trial date. Let's convert that docket call to a final status conference. Cancel that final civil pretrial on March 23rd. And at that final status conference, I will hear from you all either yay, we did it, or no, we didn't. And I will just get you either a new trial date that we have a better idea, where we are, what needs to happen, if anything else, and just basically go from there. How does that sound?
That works for us.
Your Honor.
How about you, Mr. Shelley? Sorry, I cut out.
Oh, that's fine with me, Your Honor.
Great. Thank you all. Appreciate your work. We'll see you on the 20th of April, all ready to have this disposed. Great. Thank you, guys. Okay, who's next, Chewy?
Judge, top of page 7.
Okay.
Cause number 2021 DCB 1665. El Paso Area Teachers Federal Credit Union versus Ariana Chavez. Announcement to council, please.
Thank you. Hector Beltran on behalf of the plaintiff.
Okay, sorry. Just needed to mute that. Okay, no one here on behalf of Ms. Chavez. Anyone? No? Mr. Beltran, you may proceed on your default.
Thank you, Your Honor. The underlying debt arises out of a default on an auto loan. The original amount of the loan was a little under $28,000. The loan date was October 25th, 2018. The date of default was February the 9th of 2020. Thereafter, suit was filed in this matter on May the 17th of 2021. Service of the lawsuit was obtained on, forgive me, on December 23rd, 2021. The time for answering the lawsuit has come and passed. And as a result, a motion for default judgment was filed by our office on behalf of the plaintiff on February the 14th, 2022. That motion for default judgment contains all the evidence we believe is necessary to allow the court to grant default this day. The evidence includes the affidavit of Joanna Alvarado from El Paso Area Teachers Federal Credit Union, who, among other things, averts that after all just and lawful offsets and credits are granted the defendant, the amount of $11,376.63 remains due and owing. There's the affidavit of Angelica B. Carrion Beltran as to attorney's fees, and she states under oath that a reasonable and necessary attorney fee in a case such as this would be $1,500. We've also included the certificate of last known mailing address for the defendant, Ariana Michelle Chavez, that being 370 Thorn Avenue, Apartment A, El Paso, Texas, 79932, and a non-military affidavit also signed by Angelica B. Carrion Beltran that shows, that includes a copy of the Department of Defense Manpower Data Center report indicating that nobody by the name of Ariana Michelle Chavez is presently serving in the United States Armed Forces. Notice of today's hearing was sent to the defendant. That was sent on February the 14th of 2022, and she was advised of today's hearing commencing at 1:30 in the afternoon. At this time, the plaintiff moves for default judgment, seeking a judgment against the defendant in the amount of $11,376.63, plus $1,500 in attorney's fees, costs of court, prejudgment interest at the maximum amount allowed by law, and post-judgment interest at the rate of 5% per year on the total judgment from the date of judgment until paid in full, as well as any other relief that plaintiff may be justly entitled to.
Thank you, Mr. Beltran. The default will be granted. What I was looking for was the actual proposed default judgment. I don't show, and I was inquiring with the clerks if they had was the proposed default. If you could forward that, please, to the court.
Absolutely.
And I'll sign off on that and get that processed today.
Thank you, Your Honor. We'll take care of it.
Thank you for your time. Thank you very
Have a
much.
wonderful day.
You
Bye-bye.
too. Who's next, Chuy?
Okay, Judge, 4284, page 7 is
Go ahead.
it's cause number 2021 DCB 4284, City Link Trucking Inc. versus Dump Bodies Inc. Announcement of council, please.
Hi, Judge Michelle Esparza here for City Link Trucking.
Hello.
Tony Aguilar for Dump Bodies Inc.
Hello, Mr. Aguilar. Good afternoon. We're set for a scheduling status conference. What were you all looking for? Maybe a jury trial a year out, or where are we? What are we doing on this one?
I'm waiting for them to provide me the responses to requests for disclosure within the 30 days as allowed by Rule 194. I haven't received them yet, so I haven't done any discovery yet. We filed our answer on January 28th. So we really haven't had time to do much. I don't understand their pleading, so I'm waiting for the responses to requests for disclosure to see whether or not I need to even file special exceptions.
Okay, so we need to get a scheduling order going. Normally what I will do, Mr. Aguilar, is either put you on back in pre-COVID days, it would be either a 9-month or a 12-month timetable in terms of jury trials. And do a scheduling order that followed, that jury trial date. I think realistically, our jury trials our trial dates are easily a year out. So for today's hearing, I mean, there may be things that you want to file with the court and schedule hearings on, but the purpose of today's hearing is just to get that scheduling order in place. If you need other hearings in the interim, feel free to file whatever pleadings, motions that you need to and request the hearing via email. But for now, what I will do is, unless I hear differently from you all, I'll put you into March of 2023, looking at March 3rd of, March 3rd of 2023 as our trial date. We will send you a form scheduling order, both to you, Mr. Aguilar, and Mrs. Esparza. And if you will just go through, the trial will be March 3rd, docket call March 1st. If you all have and can agree to a mediator, please indicate that as well. If not, the court will select one. There will then be the appropriate blanks for deadlines. And then we'll have dates. There will be a setting 2 weeks out from today by which that scheduling order is due to be returned to the court via email. If we don't receive it, then you all are required to be here to see what the holdup is. But if we receive it, you're not required to appear. We'll have dates. And then again, if there's something that requires a hearing, please file your motion and let the court know via email, and we'll get you a hearing if it's outside of those dates. Does that make sense?
Yes, perfect. We'll work on, I think we can work on the scheduling order and so we can get started on discovery and get the case moving.
Mr. Aguilar, is that good?
That's fine with me, Judge. I just want to get it worked so we can get the case tried.
Yes, sir. Thank you very much. We'll get you our scheduling order and get you the setting.
Can I be excused?
Yes, sir. Thank you very much. Thank you, Mrs. Garza.
Thank you.
Bye.
Bye.
Bye-bye. Who's next, Trudy?
Okay, Judge, following case 2712,
Go ahead.
cause number 2020 DCB 2712. Kaylee Marie Quartermain versus Andre Michael Artiaga et al. Announcement of council, please.
Joe Shelley on behalf of the plaintiff.
Cliff Jessup here on behalf of the defendant.
Okay, so I have a notation. I have a notation here, no future settings to check on remaining party. Is that current or was that for something? Notice of non-suit. Okay, what's going on, gentlemen?
Judge, this case has been settled. Plaintiff has been waiting on funding on the settlement draft. We have it in hand. We talked to plaintiff's counsel's office. I think they're coming by to pick it up today, and we'll exchange the dismissal documents today.
Okay, good. So I'm gonna put you for a status in 1 week. How about that? And then I'm not gonna see you anymore on this case, right?
No, ma'am.
Yes, Your Honor, we'll get that non-suit filed.
Okay. Thank you, guys. Appreciate you. Take care.
Thank you, Judge.
Your Honor.
Okay, who's next, Chewy?
Okay, Judge, bottom of page 7,
Go ahead.
cause number 2021 DCB 3487, El Paso Nursing and Rehab Center versus Josefina Vargas. Announcement of council, please.
Attorney Howard Kahn for Plaintiff El Paso Nursing and Rehab Center.
Okay, and no one here on behalf of Ms. Vargas, correct? Certificate
Correct.
of service.
This is a motion for default. We filed it back in November. We got a hearing date. We sent out our papers. There's still no answer. And we did file certificates of service of sending out the motion for default to Ms. Vargas. We even filed, and as part of that, we showed the USPS tracking number and the actual signed green card.
Okay,
So-
and so she received that back in November?
She did.
Okay,
And as of yesterday, when I was able to check the file, I didn't see that an answer has been filed yet.
okay. All right, go ahead, Mr. Khan.
Thank you, Your Honor. This suit was filed on October 1st. Claim for nursing home services for $13,313.69. This is done on a suit on sworn account under Rule 185. There's been no denial. It's sworn to. We filed our motion for default. I attached an attorney's fees affidavit for $1,500. I attached the non-military status affidavits of B1 and B1 saying she's not serving. So we asked for a default for $13,313.69, $1,500 in attorney's fees and court costs. And we did send in and file a proposed judgment. I think this morning or maybe late yesterday, maybe this morning.
I believe, at least I received it yesterday. I don't know if when it was sent to the court, but I received it yesterday. A few things. So the notice, Mr. Khan, the notice, the certificate of service is Okay, so it's noticed that the motion for default was served, but the notice of the actual hearing, did you send Ms. Vargas notice of the hearing as well?
I have not, I don't have any evidence that I did that. I don't have a copy of that order. I should have it, but I don't, because I looked for that. So I did not send her a notice of the hearing for today.
Okay, that's one thing. Generally, I'll look for, and the reason I was looking at that is because we set the hearing on, I believe, February 14th for today. If we had sent notice to Ms. Vargas, which I assume is going to be fairly simple because the actual default judgment, basically she signed off on the green card, right?
Yes.
So what I'm going to do on this is I'm just going to hold off on the default. We're going to reset it for, we'll do 30 days just to make sure. And if you will forward notice, we'll reset the hearing on the default for 30 days. If you'll just have proof of notice regarding the hearing, Esteban, if we can get the hearing reset for 30 days and get her notice of that hearing in 30 days, we'll come back, have our hearing, and once she has notice of the hearing, we're basically good to go. Okay?
Yep.
Perfect. Perfect. Yeah, because it's been on, I mean, she's got notice of the default. I just don't know that I'm not satisfied. We got notice to her that she's of the hearing.
Absolutely, Your Honor.
All right.
So
Thanks a lot.
I can expect a court docket order specifying the actual date and time that I can print
Yes,
out and
sir.
send a copy of it to her. Great. Okay.
Yes,
May I
sir.
be excused, Your Honor?
You may. Thank
Thank
you
you.
very much. Okay. Who's next, Chewy?
Okay, Judge, I've got, I believe it's Mr. Hedicky on the phone there. And he's here, I believe, with his client, Mr. Hull. I believe we're just waiting for Mr. Ellis.
Okay. And that's kind of who we need.
And then Mr. Murphy is here for Jose Vega on page 7, Judge, but we're waiting for Mr. Enriquez or somebody on his behalf.
Mr. Murphy, have you spoken with Mr. Enriquez? He might have been in a cloud after yesterday. Might have been a little busy.
I haven't, Judge. I can reach out to Mr. Vega and see if he has and see what's going on there.
Okay, unless, I mean, we can try calling him, but you know, yesterday was a busy day, I would imagine, so. We'll take a break. Well, do we have everybody here on Hedicky?
Mr.
No,
Batin, just let me
Yes,
know.
yes, Your Honor. This is Robert Hedicky. I'm on my cell phone.
Got you. I just think we're missing Mr. Ellis, so if you'll hold on a second.
And Mr. Enriquez should be logging in shortly,